It is supposed to be come in the list in 14.
Use the microphone. Yes.
The returnable date is 14/3/2026, but the matter is not in the list. Currently including
No.
inclusion in the
No, sorry. Yes.
Your Lordship, the matter was supposed to appear in the 11th March, but the matter is not appearing in the list. The urgency is that if the matter is not heard, the matter might get infructuous.
Very well. Yes. Nothing.
My lord, may I be permitted to mention for contempt application?
Contempt application what?
My lord, inclusion.
No. No inclusions. Please don't mention.
My lord, may I be permitted to mention a matter for restoration? My lord, the
My
petitioner.
lord, withdraw.
My lord, the petitioner is a Anganwadi helper. File the petition for the upgradation of the Anganwadi helper to Anganwadi helper.
Yes.
My lord,
Nothing.
may I permitted to mention a matter for non-prosecution? My
Give.
lord. My lord, for non-prosecution of contempt.
May I permit to mention restoration for application
Nothing.
listed, my lord?
No.
My lord, this
Which date I have
motion it got released from court 19 under Justice Bhattacharya. Actually, mistakenly we filed this case under Land Acquisition Act, but it will be Service Act under service matter. So it got released.
Come next month. Yes. Call the list, please.
In item 6, I am appealing for the contemptuous. It appears that they have filed one G application which is there in the list, but no copy has been served upon us.
No copy has been served, my lord.
It has been served.
No copy.
No copy has been served.
But I have not.
Whatever services there, my lord.
Served copies. Who are you?
My lord, I am not a party to the proceeding, my lord, in the read, but I am affected by the order.
So
Yes.
why this is
Because-
a contempt application? Why will your application be taken up for consideration?
Because my lord, if the demolition take place, I am there. I am a lawful owner for till last 100 years, my lord.
You
And I
stay
have not
there
been able to-
100 years, the building
So, my
will
lord,
come down.
kindly hear the application, my lord. Then I will
Serve copies.
Yes, definitely, my lord.
Main contempt
position?
application is returnable on 20th
And the
April,
application
Lordship.
is pending before the building tribunal also.
Serve copy.
Definitely, my lord.
Let copy of the application be served upon all the parties. Released on 20th April.
Grateful, my lord.
For the respondent transport corporation, my lord, my senior is on our legs before court 30. I'm praying for not today.
I am for the state, lord.
State. What is the matter?
Well, this matter we are challenging the final order, my lord,
Final order of
dismissal from the service. The petitioner used to work, my lord, as a conductor.
affidavits ready?
Yes, my lord. There is last occasion, my lord had asked a question. I have received the specific instruction. I think, my lord, my understanding is, my lord, I have to withdraw this application.
You have to
With
withdraw.
the liberty to file afresh.
Why?
I think that way it can be taken, because the point is that, my lord, we are challenging the order on the basis of the fact that they have passed it on the basis of their standing orders. Now, the standing order has to be challenged. That point I think I have not taken. Unfortunately,
It's up to you. I do not know if you want.
the second way could be that my lord can grant me the liberty to file a CAN application. I'll bring all these facts. Then my lord can take this forward. Second,
Main thing, in the writ petition, it is not there, and by way of application, the court is
I
going
know
to permit you.
it can't be done.
Then?
Then I have to withdraw, my lord. With the
It's
liberty,
up
my lord
to
can
you, because
my lord can dispose it off with the liberty that I can come back again.
why?
Because then I will challenge the constitutionality of this.
Why will the court give you this liberty when the issue has been raised by the respondents after filing of affidavits? Now you say you'll be given liberty. What are you submitting?
Then how can I tackle?
If you cannot, you cannot. You fail.
No, that way, my lord, my petitioner will suffer.
It's up to you. It cannot be done this way. What is the error in the final order?
the person who has conducted the entire charge sheet, the person who issued the charge sheet, he's the one who's conducted the entire trial. He's the only one who has passed the order.
Yes.
issuing order. Now, my point is, they have passed this order, my lord, under their service rule.
Their service rule.
Yes, this one, this standing order.
All right.
This is the order, my lord. Calcutta Tramways Corporation Limited, incorporated in England. This is 2008. The person who has issued it, he has affixed his signature with the time that is 2008. My order is passed in 2019.
Yes.
Now, as per this order, my lord, if you will look, the order has been passed under, my lord, Rule 12A 9. That is on the charge of theft. That's the thing, my lord. As per their order, under Rule 13, it says that no employee will be dismissed or discharged except by a departmental head. Now, kindly, if you see the definition that is given, Rule 1, definition and classifications, the department of head, this term has also been, my lord, defined. The head of a department means the head of one of the various departments of the Calcutta Tramway Corporation Limited or such other official to whom his powers have been delegated. Now, the powers have been delegated upon
Deputy Managing Director.
Yes.
So,
now, in such a manner that he is the one who starts the trial, he is the one who takes it to
Finish
the
it off.
logical conclusion.
Yes, nothing doing. If the law permits it, nothing doing. Please come.
But I am challenging that aspect, my lord. Kindly dispose it off by keeping this window open, or else I'll be seriously prejudiced.
The petitioner is a dismissed employee of the West Bengal Transport Corporation Limited, erstwhile the Calcutta Tramways Company, within bracket 1978 Limited. Step. The order of dismissal was passed upon granting opportunity of hearing to the petitioner and on following the amended standing order of the company.
My lord wants a copy.
No. Step. Submission of the petitioner is that the authority who issued the show cause is the authority who proceeded with the entire proceeding and passed final order in the matter. Step. From the final order, it appears that the petitioner was tried under section 12 within bracket small a within bracket 9 of the amending standing order of the company. Achha, he was tried and punished. Punished under section 12A. Stop. The petitioner submits that the petitioner ought to have challenged the amending standing orders which permits the the departmental head or his delegated officer to pass an order of punishment. Stop. Paragraph. Not the learned advocate for the petitioner submits that the petitioner intends to challenge the standing orders. Stop. The same is not under challenge in the instant proceeding. Stop. There is no further point which the petitioner raises in the instant writ petition. Paragraph. As it appears that the final order has been passed in accordance with the service rule of the petitioner, accordingly, service rule of the petitioner, upon compliance of the principle of natural justice, accordingly, there is no scope for interference in the impugned final order dated 30th of July 2024. Stop. The writ petition fails and is hereby dismissed.
Dispose it with, my lord. Kindly dispose it with the liberty to come back, my lord.
Next.
This person will suffer, my lord. Please.
Appeal number 9, Lordship, I am led by Mr. Huda, Lordship. I am seeking, Lordship, can you keep it on the next week, Lordship?
Next week?
Lordship.
Why?
Mr. Huda is appearing in this matter, Lordship.
Hmm.
Come for his personal difficulties, Lordship. So I am filing the exception as per the order dated 26.
1 mark short of the cutoff.
Lordship.
No, my lord, one question has been challenged. My lord, if your lordship.
Which examination?
My lord, the
Lower division,
lower division.
appellate and original side establishments of this court.
Yes.
All right, then 1 mark. What happened?
Not 1 mark, my lord. The question, the veracity of the question, my lord, if one sister, brother, the total number will be 8 or
Alright.
14.
All right.
Lordship directed me to submit a further report. We have submitted the further report, my lord,
Where? In the department?
in the department
Uh,
on 31st. On 31st. of
what does it say?
My lord, it says that, my lord, objections were received. A total of 8 objections after, my lord, publication of the provisional list. Those were, my lord, carefully considered by the paper setter. Then he forwarded the opinion before the, my lord, the Honorable Recruitment Committee. The Recruitment Committee approved that, my lord, the paper setter's opinion. And then it was also referred before the Honorable Chief Justice. My lord, the Chief Justice has approved that.
And that is the answer
That is
which
the
has
answer,
been
yes.
found to be incorrect
In the final answer.
in the final answer key.
And my lord, even after publication of the final answer key, my lord, objections were received. Though there was no scope to, my lord, interfere with that, still, my lord, the Honorable Recruitment Committee, my lord, considered those opinions, those objections, and yet again, my lord, approved that the paper setters.
That's right. Very well. Your exception filed by the petitioner to the
Yeah.
report filed by the respondent number
To the
2.
further report filed.
Further report filed by the respondent number 2, affirmed on 31st March 2026, is taken on record. Stop. On the prayer made on behalf of the learned advocate representing the petitioner, hearing of the writ petition stands adjourned till 20th Monday week,
Lordship.
20th.
Grateful.
Devdatta Basu is appearing for the petitioner. He is engaged before court number 38. I am praying for not today.
Not today.
Lordship, I am appearing for the respondent in item 11. But,
Yes.
Lordship, I am for the respondent in item 11, but the petitioner is not.
Yeah, what is your submission?
Lordship, I am praying for a short passover as my senior is on legs in other court.
None appears for the petitioner. List on 8th of June. Not today. 13, not today.
Let's say appear for the petitioner. This matter,
I am appearing for Bose Institute.
this matter relates to reversion of employees who have been promoted.
Before my learned friend starts, Milord,
Appeal is pending before a coordinate bench in a similar matter.
yes, Milord, the similar matter has been heard out, and Milord, we
enough.
preferred an appeal, Milord. We and Milord, the Union of India, Milord, my learned
Also filed the
friends clan.
In fact, they were listed, Lordship, but since the respondents had mentioned the matter, Justice Madhuresh Rao directed the matter to go out.
May I just indicate this? May I just indicate this?
We are all ready.
The authorities have given a different impression. The matter was adjourned on 2 occasions.
Where?
Before this honorable court, on the ground that steps are being taken before the appeal court. Lastly, it appeared, on 6th February, on the same ground, I came across an order passed in the appeal. Where from it appears no steps whatsoever was taken at the instance of the authorities. In fact, these steps were taken at the instance of the writ petitioner respondent. They are sitting tight over the appeal.
Yes, what is the matter now?
order.
I appeal court order last date holo. Before
But
the division
the appeal mentioned the matter because
they have given an impression that they will take steps before the appeal court to get the matter heard.
Yes.
Because there is an order passed by the coordinate bench against the impugned or same order, which has been set aside. Well, it's September order. Well, they appeal, it was adjourned in October, again in February. Well, it be in April.
What to do?
Lordship,
You all are not taking steps before the appeal court.
Lordship, we had taken steps.
No, but then the order doesn't reflect. So it in fact reflects that you did not take any steps.
The respondents.
Respondents means the writ petitioner.
Respondent is nahi chilo.
Could I just see the order? I'll just check.
Yes, it is the writ petitioner who took steps
Yes,
before
yes,
the appeal
yes,
court, and the
yes,
court
and
directed the appeal to go out of the list because the appellant.
Justice is not sitting now. After the 16th, we'll be mentioning the matter again. He's not sitting till the 16th. Therefore, he is directed.
Please come.
It may just make one submission. On the last occasion, I have indicated this. Well, the challenge is to order of reversion. The case is that some promotion. Reversion.
Reversion of what?
There was a promotion policy implemented in the year 2008. I obtained certain benefit under the promotion policy. That policy was set at not after 15 years. I am threatened with recovery. In the meantime, my lordship, I have taken out an application. 5 petition out of 12, have superannuated. Their gratuity has been withheld. One petitioner is a cancer patient. I have taken out an application. The judgment starting from Rafiq Pasimal and latest in 2025, Joginder Sahu. If the fault, there is no fault or misrepresentation on the part of the petitioner, recovery cannot sustain. So I have taken out that application. If your lordship kindly takes up that application any day subject to your lordship's convenience.
The judgment of Rafiq Masi is not applicable here. I'll try to satisfy your
Kindly keep that matter
because there was an undertaking all along that anything excess paid, they will return the same.
Rafiq Masi has evolved a lot in
The
2025.
Supreme Court thereafter,
I'm carrying this judgment
from Rafiq Masi.
I'm carrying this judgment in the same facts of circumstances of case. Lordship, recovery cannot sustain.
All right, please come.
Kindly take that application anytime.
Pendency of the appeal, the respondents were able to get the matter adjourned on the last date of hearing. Stop today. Pendency of the appeal in a similar matter. Today, learned advocate for the writ petitioner produces copy of the order dated 1st April 2026, passed by the Honorable Division Bench in the said similar matter, which is pending before the Honorable Appeal Court in MAT 2231 of 2025. In the matter of Union of India and others versus such and such. Wherefrom it appears that the respondents in the present writ petition did not take any steps before the Honorable Division Bench for getting the matter heard. Stop. Paragraph. Learned advocate for the petitioner submits that the respondents are trying to implement the order of reversion of promotion and are taking steps for recovery of the amount paid to the petitioners. Stop. Some of the petitioners have already superannuated. Stop. They are not being paid their gratuity. Stop. Threats are given out for recovery of the excess amount paid to them. Stop. It has been submitted that the petitioners are nowhere at fault for the money that had been paid to them in their promotional post. Stop. an application has been filed seeking an order restraining the authority from proceeding with the recovery of the excess amount. Next paragraph. Learned advocate representing the respondents submits that steps will be taken for enlisting the matter before the Honorable Division Bench. Stop paragraph. In view of the aforesaid submission,
No, Lordship, recovery, in fact,
Recovery we are not doing.
We'll show from the
Learned
application.
friend
also.
can show
I will
a
show.
single document that we are
will.
trying
I
to
will.
recover.
well, if you are not doing, then
We
there
are
is
not
no
doing, my
problem.
lord.
Malady, they have recovered, Malady.
4th of May. Stop in the event. There is no order staying the operation of the order passed in the similar matter, right, by the said date, comma, then the matter will be taken up for consideration on the basis of the documents already on record.
Grateful.
Like in that event, I'll place my application on that day.
Certainly.
So grateful, Your Lordship.
My lord, since my learned friend has filed an application, my lord, may I just file our opposition, my lord, if your lordship kindly directs and permit us, my lord, to do so.
It will be open for the respondents to file opposition to the connecting application Can 2 of 2026 by 24th April.
Grateful one.
Yeah. So grateful, my lord. So grateful.
Grateful one.
May it please your lordship, my lord. My lord, on the last occasion, my lord, your lordship may kindly recollect, my lord, this is the point, my lord, which was to be decided by your lordship, my lord, which the point which was raised, my lord. That is, my lord, an employee, my lord, question is, my lord, an employee who has, my lord, submitted resignation under a circumstances. And, my lord, before acceptance of the said resignation, whether they, when he has made an application for withdrawal of the suspension or withdrawal of the resignation order, whether that acceptance subsequently before that can be a ground, my lord, that I can claim that I was in service. My service cannot be, reason cannot be said to have been accepted because I have an option, my lord. To that, and secondly, my lord, the order of release which was passed after, my lord, without, my lord, after, my lord, without considering the, my lord, withdrawal letter, that therein there was a clause that you have been released, but you have to continue for doing certain works. So my respectful submission before your lordship would be, in such a case, if such a, my lord, condition is there, contingent, then the juror relationship, employer-employee relationship does not cease to exist. Number two, to that extent, my lord, I was searching, my lord, I'm fortunate, my lord, mainly, my lord, on the basis, on the, my lord, criminal jurisdiction, I have to, my lord, to explore, my lord, certain judgments, my lord. Following the judgments of the Honorable Supreme Court, my lord, one judgment passed by the Honorable Dr. Justice Ajay Kumar Mukherjee, my lord, where 2-3 judgments were, my lord, considered on the point, my lord, and it was decided, my lord, in 2024 that no, before action, unless there is a specific condition in the service rule to that effect, then before acceptance, if an employee who has filed the resignation, if he withdraws his made an application for withdrawal, then it cannot be said to have been accepted. That acceptance, my lord, before, my lord,
Show me the dates and the documents.
My lord, may I submit one thing, my lord? My lord, what your lordship, what has fallen from your lordship on the last occasion, my lord, I have gone through. My lord, this says that yes, prior.
Let him place his case first.
Yes.
Lordship.
So, my lord, kindly have, my lord, in the pleadings, my lord, although may kindly have a look at, my lord, the order, my lord, which was, my lord, this one. My lord, kindly have a look. Index তৈরি করেছেন সেটা কোথায় দেয়? No, এটা না। My lord, the order of resignation first, my lord. Resignation, my lord. first, my lord, kindly have a look, my lord, that page 34. P7. Then, my lord, kindly have a look at.
1 minute. 34, prayer for resignation.
Yes,
What
ma'am.
is the post that you are serving?
Well, he's
The
a
project
contractual
officer.
employee, your lordship.
No, my lord, that is not, that was
Well,
approved.
I'll
but
show
no,
before your lordship.
Just wait. Please take your seat. Yes.
it was subsequently approved, my lord. I will show to your lordship, my lord. Then,
What
my
is
lord,
the post? Show me your
project
post,
officer, my lord.
your appointment letter.
The letter of appointment, my lord. P1, kindly have a look at.
Yes.
Yes. P1.
Contractual basis 2017 for a period of 1 year.
Yeah.
Special officer.
Thereafter, my lord. Thereafter, my lord,
officer.
kindly have a look at page 22,
Hmm.
annexure P2, my lord.
Yes.
Henceforth, Vishwarup special officer so and so, who is a degree mechanical, will take over all the mechanical works in the capacity of assistant engineer as and when required.
Hmm.
The project officer, my lord. Here, initial appointment was that, my lord. Thereafter, my lord, after probation, my lord, he was, my lord. This is the, my lord, order which
Where
was
is the
issued.
probation?
My lord.
Where is the probation?
My lord, that is, my lord, that contractual appointment.
Yes.
Appointment in support of academic qualification is so and so, time of joining so and so. I leave rules, leave and other rules will be as per rules of the corporation.
Hmm.
No, my lord, that is, my lord, temporary basis, my lord, in all, my lord, in all appointments, your lordship kindly consider, my lord, it is written, my lord, temporary basis. That doesn't mean, my lord, that whether subsequently it was approved or not, my lord, whether he was allowed to continue or not. Then, my lord, their confirmation, my lord, the rule says, my lord, that 5, rule 5, my lord, I got a copy ache. देखिए दिन तो जैसे all appointments on entry into government shall initially be made temporary basis. My lord, kindly have a look at rule 4, my lord. 5. Appointment on probation and upon so and so. A government employee shall be deemed to be on probation on completion of continuous period of 2 years, my lord. Shall be confirmed and made permanent on satisfactory completion of a period of probation. While passing of the departmental examination in so and so, so and so. But this does not apply, my lord, so far as the, my lord, first, my lord, which was submitting before lordship, my lord. My learned friend's contention that he was temporary, my lord, he was a casual employee, my lord, contractual employee. Contractual. That is not correct, my lord.
That is not correct.
Yes.
Where from? Where from I get to know that it is not correct?
There are P2, kindly have a look at.
Firstly, tell me that whether this rule apply in your case or not.
My lord, that is, my lord, this rule, my lord, although, my lord, it is a, my lord, corporation undertaking, my lord, no other service rule is there. So, my lord, this may be applicable, my lord, mutatis mutandis, my lord, so far as the, my lord, undertaking is concerned. It is not a government, my lord, the undertaking, my lord.
Hmm.
Secondly, my lord,
I am not able to understand. I am not able to understand your service rules.
Lord, there is no, my lord, so far as this, my lord, employment is concerned, my lord, there is no specific service rules, my learned
There
friend.
is no specific service. Your learned friend is saying there is a service rule.
Well, corporation has their service rules, Malad. Since he is a contractual employee, Malad, he will.
Contractual employee, nowhere it is written that Miraj contractual employee.
Let him submit, Malad, please.
Yes.
Nowhere it is in kindly
Page
have a look.
21.
Yes.
You have been appointed on contractual basis for 1 year.
Yes.
Thereafter, what happened?
Thereafter, my lord,
Page 22.
Yes, 1 year, my lord.
1 year.
Yes.
Then
my lord, kindly have a look at medical document for us. Then, my lord, my lord, he was transferred to some other project, my lord. Sankarpur project, my lord. My lord, this is one of the, my lord, branches of the, my lord, that is corporation, my lord. Then, my lord,
you still remain a contractual employee.
My lord,
If you want to come ready, come ready. Don't take instructions by this way and make submission, because the court is fighting for time for other matters.
Yes, my lord. Yes.
So on legs, if you want to take instruction, then the court cannot permit that time. I am unable to understand how from contractual you suddenly claim permanency in the job. How? Show me some document that you are a permanent employee.
Malad,
My
we'll
lord,
see
my lord,
the
kindly have a
notification
look.
by which they were employed, Malad. In their exception only they have given. If your lordship kindly takes up the exception to the report, Malad, which we have filed. Lordship will come on page number 6, your lordship. This was the notification based upon which, Malad, the
My lord,
petitioner
kindly have
was-
a look at, my lord, that my lord, 17, my lord,
Speak together,
that is
let us kindly seize, Malad.
17, my lord, is the, my lord, date, my lord, of appointment, my lord. Now he filed the resignation, my lord. Kindly have a look, my lord, from 17 to 23, my lord.
Exception ta khuje din na.
He submitted, my lord, 17 to
I
18.
think my officer will be able to find it out better than I do.
Lordship, no, to
Huh?
help your lordship.
You
To
think
help-
so?
To help your lordship.
You are wrong.
Lordship, I beg pardon.
Certainly not.
I beg pardon.
Yes.
So, my lord, kindly see, my lord, the appointment was made on, my lord, 17th, my lord.
Yes, exception which what you want to show.
Malad, exception page number 6, your lordship. If
Yes.
your lordship kindly sees, this is the notification based upon which, Malad, the petitioners was engaged.
Yes.
Malad, West Bengal Fisheries Corporation Limited, Government of West Bengal, Vides Sachin, Kolkata are filling up of post of special officer or port officer fishing harbour on contractual basis for a period of 1 year with consolidated remuneration for of rupees 2,000 per month.
20,000, madam.
20,000 per month. Malad, this was the notification.
Yes.
Malad, based upon which they were employed, Malad, on a he was employed on a contractual basis. If Malad kindly comes to the subsequent page, Malad, which is page number 7, Malad, year by year, whenever he was transferred, Malad, it was for 1 year and purely on contractual basis and as and when required basis, your lordship. If lordship kindly turns to page number 7, Shri Bishoru Board is hereby appointed on contractual basis for 1 year in the post of special officer or post officer under the West
Yes,
Bengal.
yes, that's page 21 in the writ petition.
Yes, my lord.
And the next
My lord,
one
the
is page
authority may also
22.
terminate the service in case of he or she is found guilty of insubordination or whatever. My lord,
Yes.
my lord, the next page also says, my lord, as and
I
when
am
required basis.
unable to take you as a permanent employee. If you want
My lord,
to,
why submit? My lord, I will
Yes.
come prepared, my lord, but the document shows, my lord, from 17, my lord.
Yes.
Appointment on 17. My lord, date of, my lord, submission of resignation kindly consider. What is the date of resignation? 17, 18, 19, 20. And my lord, the date of resignation is, my lord, 23.
yes.
So, my lord, if I accept, my lord, that 2 years, my lord, if the probation period is there,
Why
my
did
lord,
you accept? From where are you accepting?
because we're contractual employee, my lord, there is nowhere.
There is no probation period for a contractual employee.
My lord, kindly have a look at, my lord, the advertisement contractual employee, but appointment letter, my lord, kindly see
Yes.
on temporary basis, not
Contract-
contractual basis.
Absolutely contractual.
So
Check up
kindly-
your appointment letter.
Yes.
Page 21 of the writ petition.
Yes. Temporary basis and may be terminated with
Sir,
1 month's notice.
second line. Look at it. You hereby appointed on contractual basis for a period of 1 year.
Right,
Learned advocate appearing for the petitioner to come properly prepared. Released on when?
kindly after 24th then on a subject to
24th,
after 24th, my lord.
27th.
27.
Next.
My lord, I beg pardon, my lord, I just only tried.
Like here in this case, a nice thing has been happened by the SSC, my lord. The petitioner before your lordships applied for the post of constable first time in the year 2022. A registration is one-time registration and it is linked with the Aadhaar and Aadhaar linked mobile number. Nobody can change, nobody can access except the candidate. My lord, this thing has been happened in the year 2022. Selection process starts. I applied for the post of the constable. At the time of filling up my form, I made a mistake to incorporate my mother's and father's name. There is a deviation from in accordance with my matriculation certificate. Lakhon Kumar Shaw,
Others
Lakhon
mistaken.
Kumar Shaw,
Huh?
Lakhon Shaw. That has been done. Lokhi Narayan Devi, Lokhi Narayani. That's had been happened at the time of filling up the form. As because it is a one-time registration,
Yes. How
that
can you
in that process I could not qualify the written examination. Subsequently, thereafter, in the 24 selection process, 23 there was no selection process. In 24, when the advertisement was published for notification, I made a representation before the SSC authority because it could not be rectified by me through online. I made a representation. Several times I went the my lord, here the Eastern Regional Office. They verbally told me that it will be rectified at the time of submission of this year application. I tried for long time, since 1 month. It was open for 1 month for last date. When I could not, I make a videograph and submitted the form, could not rectify my mother's and father's name. I applied, I make my submitted my application as per the registration. As because it, when I make my registration number, automatically a page opened and there is every information there are. I only incorporate the extra qualification or extra information in the application. My lord, I made a videograph that I could not change the name of my father's and mother's name. I appeared the written examination. They issued my admit card. I appeared the examination. I passed the written examination and scored
And
good
this
marks.
time they could not understand
Yes.
that your mother's father's name
Yes,
is wrong.
I am coming, my lord. My lord, what happened? I passed the PST PET. At the time of medical examination, it is the notification that the document verification will be done. At the time of document verification, this thing has happened. They find out that my mother's name and father's name is not matching with my matriculation certificate. I told the whole story to them. They told me, suggest me, you make a affidavit. I made that affidavit, first class magistrate affidavit, and asked to come next date. I go there and rejected my candidature only on that ground. My lord, I am taking that your lordship kindly come to page what they have been stated. My lord, page 38, 37, 35 rather. This is the
What
final.
has happened?
But he is not prepared, my lord. He has not got the feet, my lord.
Who are you appearing for?
My lord, Union of India, my lord, I have asked for the instructions, my lord. Today we are totally handicapped. The person who is supposed to submit, give me the report has not come yet, my lord.
Yes.
Both 3 and
This
4,
is
my
a
lord.
matter of 2024. How can you not be prepared? This is not coming for the first time.
Yes, my lord.
There was a direction to file the report.
Yes, there was
as
a
yet
direction
not.
and it is recorded despite sufficient time given. You have not filed the report. What is this?
My
How
lord,
many time?
kindly give us a last chance, my lord. Let us come back on next week on any date after Wednesday, my lord. We are going to deal with it,
More than 1 year has elapsed.
my lord.
The recruitment process, the year has gone.
My lord, I bow down, your lordship.
This is not proper. This is not the way how you conduct matters. Did you seek for instruction?
Yes, my lord, we have sought for instruction.
When?
My lord, it was a couple of months ago, my lord. We are supposed to get the instruction today.
Never be couple of months and the authority will not give you instruction. This
My lord,
is not
it does not come, my lord.
it is.
They have sent it a report. They have sent a report, my lord. And my lord, the report was not up to the mark. It was not clear.
This report is not up to the mark.
My lord, there was some technical error. So we have said,
Report?
yes, my lord.
What is the technical error? Show me the report.
My lord, I'm not handicapped today, my lord. I'm not holding that as well. I instantly said that let a fresh report come, my lord. All I'm paying for 1 week's accommodation, my lord. Let me come on next week. I will do the necessary.
Learned advocate representing the respondents again seeks extension of time for filing the report as directed by the court with the order dated 19th of February 2025. It appears that extension was granted on 19th March 2025. Stop. Even after expiry of more than 1 year, the report has not been prepared. Stop. Such stand of the respondents is not appreciated at all. Stop. As last chance, hearing of the writ petition stands adjourned till 27th April. Stop. The report shall be prepared and circulated by 21st.
Much obliged, Lordship. Grateful to Lordship.
There are 3 learned counsels appearing for the respondents.
My lord.
And nobody took the responsibility to get the report.
My lord, that
This is extremely bad. Next.
For may I please,
my lord,
I am for the
in court, same thing, my lord, same thing. On last occasion, the report has been called for. We have instructed this matter. It is the council who is supposed to give us the necessary information. My lord,
Same order will go down.
much obliged, Lordship.
Next.
Grateful, Lordship.
May I please, Lordship, I am for the petitioner. There is a application.
I'm led by Mr. I'm led by Mr. Pramit Rai, my lord. My assistant.
May I appear virtually, my lord? My junior is there.
Yes, certainly.
Deeply obliged, my lord.
My lord, in this matter, one application has been filed, my learned senior friend, and copy was served. My lord,
This is the application of the respondents.
yes, yes.
All right. What is the matter?
Matter relating to the my lord, height measurement. It is with regard to the selection process of 2024. In the notification, employment notification, there is a clause that if somebody is aggrieved to the measurement, he can file an appeal before the appellate authority on the next day through presiding officer. I missed that turn. What happened on the rush? I could not approach before the my lord, presiding officer. They driven me out from the campus. I could not able to file the appeal on the very same day through presiding officer.
My lord, I object. We do not simply throw away the candidates, my lord.
All right, let
But
him
I
say.
think my lord,
Let him say.
has no practical knowledge. I have the practical knowledge. Like
You have a practical knowledge. Don't say that.
Yes. So, my lord, I very next day or one day, today after, I made a representation appeal through email through 3 authorities: CRPF, SSC, and my lord, the nodal agency. I have made the appeal, did not consider. This honorable courts in several matters, honorable division bench hold that the don't go for a technicality. If the appeal has been filed in belated date, can be accepted and reconsidered. Only that prayer I am praying before your lordships. Let
And
my appeal for
filed after how many days?
I am giving that information, my lord. My rejection order is page 20 of my application. It is dated 21st October 2024.
Page 20, 21st October 2024. When was the examination taken?
Examination was taken for measurement.
When was it taken?
This day.
21st.
21st October 2020.
All right. This is a rejection that you
Yes, I have-
169.3.
Yes, 3.
0.7 centimeter less.
Yes.
Yes.
That
Then
very next page on the 21st November 2024, I have, well, after 1 month, about.
Kindly note that, my lord.
Yes.
After 1 month, he is preparing an appeal.
Yes.
21st of October and 21st of November.
Yes.
1 month.
Yes.
And
Well,
the requirement is you have to do it within a day.
within a day.
Immediately thereafter, it
My
could
lord,
have been accepted.
I could not. I have taken
You
the
sit in the examination 2025.
Yes.
My lord, I have said,
Then?
my lord, my age was but when I could not apply for. This is my last time. My lord, this is pending for a year. They can dispose of if they my lord, take that for the my lord, plea that the I could not have applied in the very next date or next date. My lord, this more than now. Here this my lord appeal is
And he
pending.
will,
They could not.
and we
Just
will.
wait.
My lord,
Why will they consider and why will they reply? This is the first thing.
my lord, they,
If you file it by mail, you could have done it on the next day itself. It is a mail. It is not that you go there,
but I
get
have not,
checked,
my lord, I have
not
no
accept.
knowledge that I have no knowledge that this way it can be done.
Now it is the advocate's advice.
My lord, other friends are doing that. My lord,
Yes.
yes. My lord, in these two matters, sir, একটু দেবেন এই দুটো জজ সাহেবকে বের করে। My lord, the two matters, there are 3 months delay also consider, and my lord, the honorable division bench was pleased to direct, don't go for technicality. If the person has filed the appeal, let the it be considered by taking a measurement. My lord, there are more than 3,000 posts were vacant when the petition was filed. It is on their report also says. Well, it is not that I am coming belated stage of the selection process. Prior to publishing the result, I approached before this honorable.
Belated stage filing the appeal.
Yes, but on that day, the result was not published for
Maybe
medical.
that is up to
Well, that
them.
is-
They
that
will
is-
take their own steps within their own time.
What is
And
coming from
see
your
one
lordship?
thing, 22nd November 24 you file the writ petition and 21st of November you file the mail.
Yes.
So this is absolutely
That
from
is-
the advocate's chamber it has gone.
Some other friends are make the appeal. I heard from them and
overnight
and
petition.
to the advocacy. It is
I
correct.
know
I
how
cannot
things
deviate
happen.
from this, my lord.
Mm.
What is fallen from me? But my lord, it is all of my submission. It is the my lord, the consideration of the honorable court, my lord. I am paying that only. That let my appeal be considered.
Where is the division bench's
Yes,
order?
yes, my lord, একটু স্যার দিয়ে দেবেন একটু সাহেবকে। My lord, your lordship, may I hand up my?
No, it will be there on the
Yes,
screen.
yes. My lord, paragraph 2.
2. Under normal circumstances, court would not interfere. See, here there is a difference. In the earlier process, the appellant was found qualified to have height of 170
But I am not taking
centimeters.
that point. I am also.
You are where were you checked in the earlier occasion?
Yes.
Where? Show.
I have annexed also. My lord.
Where is
not
it?
taking that point because my learned friend is now standing with the weapon that I will be.
I will be providing everything.
My lord, but he is very much sympathic to that judgment also.
No, sympathetic to the judgment, no, my lord. He's taking the
23
court.
of my application.
In a wrong
I'm
direction.
not taking that point also. My lord.
It's a wrong. My lord has already
Page
disclosed your lordship's
23.
mind that after 1
I am
month,
also
they are
more
filing,
than
they are going for an appeal.
Where is it? Where is it?
Yes, my lord.
Page 23.
First column in the box, tabulation 5 kilometers, then 1 mile, then height. With regard to the height, right hand side column measurement is 170.4 centimeter.
Oh,
It
page-
is with regard to the 2021
Oh,
reflection
page
process.
23.
35. Yes.
20,
After the appeal.
23. This is which year examination?
2021.
2021.
Yes.
170.4.
Yes.
Sujan Mullik. Same. The figures are also matching.
My lord, he's missing.
Not missing.
What?
No.
I am not missing.
Actually, you complete, then I will say.
Yes.
I will not
Well,
say.
I am not taking this point because of the reason this honorable division bench
Yes.
that you cannot take the earlier selection process.
Records, they are irrelevant.
That is the settled.
I will show you lots of the
settled
judgment.
as because the petitioner appellant went for the before the honorable Supreme Court, that matter has not yet been decided. Well, that's why I'm.
The appellant was found qualified as regards the height criteria, and it is recorded height is 70. How he was not subsequently participated. Height has been recorded as 171. He did not qualify in the race.
Well, now your lordship's skin is the one judgment is there. It is with square with this.
Judgment
There is nothing on record as how the appellant could become shorter into earlier heights.
তোমাদেরকে দিলে তোমরা দিয়ে দেবে জাজমেন্ট ওখানে অনলাইন না না আমি এখান থেকে দেবো জাজ সাহেব ওখান থেকে দেখতে পারবে হ্যাঁ এই কোর্টে আমাদের এইখানকার ও নাম্বারটা দাও তো
My lord, this judgment also with my lord on the same point. My lord, both the person has get the appointment after remeasurement. That is the thing.
May I, my lord?
Yes.
My lord, as far as the earlier recordings in earlier observations of different years, my lord, it is irrelevant. I am showing the judgment, latest judgment of our division bench, honorable division bench, my lord, it is given. Para 7, my lord. My lord, kindly come to that. My lord. Para 7, my lord.
See, this one, it was sent on the same day.
That is my whole entire.
Kaushik Burman.
Yes, my lord.
It was sent on the same day by way of appeal. In that case, it is all right.
All right.
But if you are
waiting for 1 month
by a month, why will it be allowed? Because there may be similar other candidates also. You are delayed by a month. Next day, somebody come, I am delayed by, say, 14 weeks, for 14 days, less than a month. Between the day of the examination and on the day you file the application, 1 month, there may be 1 lakh candidates within this month. If everybody comes, what is going to happen?
That's
Have
right,
you understood?
But I understand that
Then-
point. But my lord,
And the
this is the
this
last
will
time.
stay as a precedent.
Yes.
You cannot say that
All
no.
similar is- I am not taking this as a precedent. I
Yeah.
am only just
You may not see, you are relying upon this one, Prosenjit Modak, as a precedent and showing it. See, the court has allowed.
I will be showing you a different judgment, my lord. On different judgment, my lord. Absolutely, my lord. I do them. Can you come to para 7, my lord? It's my copy, my lord.
All right, doesn't matter.
Para
Yes.
7, and thereafter para 10, my lord. Passed by Honorable Chief Justice,
But
my
here
lord.
the appeal has been exhausted.
The appellant.
Difference is that.
No, I am on the point that earlier recordings are irrelevant.
No. The earlier reported that is because it relates to previous election or
Para 10, my lord. Para 10.
Para 10.
Yes, my lord. That was my submission, and the Honorable So, my lord, this is the position, latest position of the law.
And
as far as earlier recordings are concerned, my second limb of contention is, my lord, that he waited for 1 month. Now, we are not, so even if it is considered that he was driven away from that area, even it is, I strongly object to that. Then what happened? Why didn't we prefer an appeal through email on the next day, or after 2 days, or after 3 days? We will wait for
Immediately
eternity.
thereafter, I would have accepted.
We will
But
wait for the
1
eternity.
month.
And my lord,
1
my lord,
month,
may
I am
consider,
not.
my lord, in our the centers, in the examination centers, people are in thousands.
That is the reason he's saying you all drive away.
No, we didn't.
Which is actually true.
No, my lord, it is not that, my lord.
It
is
cannot
not that.
be.
We have
You have to drive away because they are in hordes.
No, actually
Please
they are
come.
in hordes, but they do not know, my lord.
my lord,
Now,
what-
after consulting the lawyers, they come to the plea.
Participated
my lord,
in the
it's a
recruitment
only
process
consideration your lordship may
for recruitment in CAPF.
My lord, it is completely completed also. 24. 24
For the
completed.
year 2024.
25 also completed.
He was found deficient in height. Stop. As per the recruitment rules, an aggrieved candidate has the right to prefer appeal against such measurement immediately on the same day. Stop paragraph. In the instant case, the petitioner filed application via email 1 month after the examination took place. Stop. The petitioner was found. Now, the height of the petitioner was recorded as 169.3 centimeters. Stop. The required height is 170 centimeters. Stop. The petitioner appeared in a similar recruitment process in an earlier occasion when his height was recorded as 170.4 centimeters. 170.4 centimeters. Stop paragraph. Learned advocate for the petitioner submits that the respondent authorities ought to have responded to the appeal preferred by the petitioner via email. Stop. The authority waited for an indefinite period of time without answering the appeal. Stop. Reliance has been placed on the judgment delivered by the Honorable Division Bench of this court on 19th of June 2025 in FMA 886 of 2025 with IA Prosenjit Modak versus wherein the court took note of the fact that the appellant had appeared in a similar examination on an earlier occasion and his height was recorded more than the height that was found on the subject here. Stop. Under such facts, the court directed the authority to reconsider the height of the candidate. Stop. In another matter, the Honorable Division Bench, Vide order dated 16th of June 2025 in MAT 322 of 2025. The Honorable Division Bench held that without standing on technicalities, the authority was directed to consider the appeal on merits in accordance with law. Stop paragraph. It has been submitted that the petitioner ought to be given the benefit of re-examination of height, as this is his last chance to appear in the recruitment process. Paragraph. The submission and prayer of the petitioner has been opposed by the learned advocate representing the Union of India. Stop. It has been submitted that the petitioner deliberately waited for a month to prefer the appeal. Stop. Had the petitioner been aggrieved, he ought to have preferred the appeal on the same day or soon thereafter. Stop. If the prayer of the petitioner is to be accepted, then there may be several other candidates whose prayer may also have to be accepted by the authority. Stop. It has been submitted that the recruitment process of the year 2024 is long over. And by now, the recruitment process of the year 2025 is also over. Stop. Reliance has been placed on the judgment delivered by the Honorable Division Bench of this court on 11th of September 2025 in the matter of FMA 964 of 2025, wherein the court held that the measurement taken on the relevant date and time of the recruitment process is important. Stop. I have heard the submissions made on behalf of both the parties. Stop. As per the recruitment rules, comma, an aggrieved candidate is required to file the appeal on the same day. Stop. The petitioner was unable to file, not unable, the petitioner did not file the appeal on the date on which his candidature stood rejected on account of deficient height. Stop. Paragraph. In a public recruitment process, comma, there are several candidates who appear for examination. Stop. The mode and manner of measuring the height is done in a standard way by following the prescribed rules. Stop. The machine and the instrument by which the measurements are taken remains the same. Stop. It may be that the petitioner may record a separate height if measured in a different machine. Stop. There may be several candidates who failed to qualify in the measurement because of not reaching the prescribed limits. Stop. If the prayer of the petitioner is to be accepted and his appeal filed nearly a month after his rejection is directed to be reconsidered, comma, then there may be several other candidates who may also approach the court seeking similar relief. Stop. The candidates in the recruitment process, now the candidates measured on the particular date
is relevant.
No, take it again. The recruitment process of the year 2024 is submitted to have been concluded long back. Stop. It will not be proper for the authority to direct remeasurement of the height of the petitioner all over again. Stop. In view of the above, the court is not inclined to accept the prayer of the petitioner seeking remeasurement. Paragraph. In the matter of Kaushik Bormon, within brackets Supra, the court noticed that the appeal by the candidate was filed through email on the same date of the examination. Stop. It is only on that ground that the court directed the authority to consider the appeal. Stop. Paragraph. In the matter of Prosenjit Modok, comma, the court took the court noticed that the candidate's measurement was found to reach the qualifying limit in the earlier examination where he participated. And on that ground, the court directed remeasurement of the height. Stop paragraph. In Harun Mia, now in a later decision by the Honorable Division Bench with the same strength in the matter of Harun Mia, held that the measurement taken on the relevant date and time is important. Stuff. Next. This court is of the opinion that the measurement taken on the spot of the examination ought to be taken into the consideration for measurement for the purpose of assessing the height of the candidate. Stuff. In view of the above, the writ petition fails and is hereby dismissed. Connecting application dismissed.
My lord, item number 6 may be kept passover for a while, my lord. 7 and 8, Mr. Pramit Roy is with me, my lord.
All right, 6 is passover, give 7.
7 and 8. 7. হ্যাঁ করবো ওটার পরেই করো না হ্যাঁ
7, my lord, may I please, lordship, I am for the petitioner. Here also, my lord, the petitioner before your lordships have participated the examination, qualified the hurdles of
Cubitus valgus in both limbs.
Both limbs, my lord. That is the ground of rejection. I have the page 26 and the my lord, the X-ray report page 27. That shows I have the carry angle of 18 and 70 degree. Page 26 is the orthopedic doctor who suggests for my lord, X-ray. I done the X-ray and then he observed that it is a 18 degree and 70 my lord, within prescribed limit of my lord, acceptance. That is all of my case. I am praying before your lordships, kindly give a direction to the M. Skolani to measure my carry angle. Whether I am within 20 degree or not, that will reveal your lordship to decide the matter. And on honorable,
I have dismissed these matters, so this is also going to be dismissed. Prefer an appeal and bring an order so that I can change my view.
Well, there are some orders.
Where?
This honorable court
No.
and the honorable Supreme Court also. Yes, my lord. My lord, this honorable court in similar situation, not similar deformities, in different deformities, and somewhere I and somewhere.
No, I have seen those orders. Please
Yes,
come.
my lord. That order, my lord,
Sumanta.
honorable court also direct.
Page 24 is the DME, RME 25. It is dismissed. Take down one more point. That is the recruitment processes of the year 2024, which is reported to be concluded long back. The state government examination cannot be accepted. Next, 8.
My lord,
Same.
lordships,
Cubitus valgus or some other deformity, but it is the same. 24 recruitment process.
yes.
Let me see the file once.
my lord, one point I should, my lord, I should argue for your lordships on
Yes.
the point your lordships indicate in your lordships order. That is the civilian hospital.
Yes,
As
yes,
my lord
yes.
friend submit in another
Right,
case.
right.
My lord, here, my lord, the medical doctor who are the examining authority, who has a degree of MBBS, and the civil doctors has also the same degree. And moreover, this is for guideline came out by the Ministry of Home Affairs, and they are not following that guideline. And another point is that it is a disease and deformities. Any doctor can indicate the disease or deformities. That is all of my submission. It is not different as my learned friend submitted in other matters that this is the civilian doctor, they could not find. My lord, it is my respectful submission before your lordships that the doctor can identify disease and deformities. That is all of
All
my
right. Dismissed. The pages are mentioned. And this is also 2024 recruitment process. So that point we
My lord.
call 6.
Item number 6.
Yes, ma'am.
6.
Hello, Jatu. Anna. Humble. My lord, I am there.
Six, my lord, also the same. Here, your lordships, one matter your lordships has hold. This is my exception to the report filed by the my lord, it is not. My lord, I should stitch it and hand it over to your lordship. My lord, this is a case where that my lord, ground of rejection is that I have a squint. My lord, neither in DME, neither in RME. They have
No, not only squint. The squint, poor distant, cardiomegaly.
DME in several grounds. Thereafter, page 21, the review medical examination, only one ground.
Squint in left eye.
Yes. No degree has been mentioned, nothing. And squint and the vision, my lord, I have checked it up myself to the my lord, NRS Medical Hospital. They stated that I have no squint. My lord, if the authority concerned may indicate in their order that I have how much of degree of squint. Nothing mentioned. Here, a detailed measurement has been given. Kindly come to page 23.
No, there is a report filed by the authority.
Yes.
What does the report say?
Report nothing.
Report says nothing?
Nothing.
Yes, report
And
say.
no
What is the
document
report?
has been annexed with the
What is your report, please say?
My lord,
regarding
DME and RME are expert bodies, my lord.
Yes,
Now he
yes,
cannot
true.
challenge the expert body.
Yes, show me what does your report say?
My lord, report was filed on the ground of vacancies on all that. Nothing on this.
that point of time.
No,
the
no,
honorable
he is
court
misleading
was-
the code actually.
I'm not. Ekdomi means
No, I am. Let me say, the report that we filed was upon the status of the vacancy,
Yes.
not about the case. The earlier the
When
court.
when I said that you have filed.
No,
they have
you
regarding the medical-
again, my lord, see.
This honorable court was.
My lord, kindly come to the earlier order of
clients to
the
file a
courted bench.
report.
No, file the report on what?
With regard to the vacancy availability.
That is there. And we filed it. We complied with the order.
Although in the report they have mentioned the why this has been rejected and why, but no documents has been produced before this honorable court in the with the.
If your lordship pleases to pass an order like that, we will file a report on that context also. But the fact is that, my lord, these are all in the process of 2024.
Yes.
Long back, my lord. Now it has become
I'm also
infructuous.
saying so that, my lord, what just now my learned friend.
Right. But it has become infructuous. What will be the use?
Yes.
Wastage
That
of
is
time.
why I have in that event, if my learned friend take that point, its my repetition is infructuous, I have my submission. If your lordships allow me, I can make my submission on that point. My lord, this writ petition was filed much earlier to publication of the result. My lord, after filing this writ application, this honorable court was, in the meantime, the result was published. Then this honorable court was pleased to direct them to disclose the vacancy availability so that this honorable court take an decision on this petition. My lord, they have disclosed, and in that report they affirm that there are 3,000 vacancies are available. Now this.
Not 3,000, 409 vacancies were available on that date.
On that day. That was merged with
And then
2025.
yes.
This recruitment process is with regard to the all over India.
No, my lord. Again.
Pan India basis.
Again,
and
same thing.
Pan India basis, there was
No.
my lord, 3,200 vacancies were available in their documents and with the
Shumanto.
my lord, may I?
Dismissed.
If your lordships permit me on the ground of my lord, on the point of my lord, the maintainability, I can.
No, not maintainability. The
My lord, this,
squint. Yes, next.
My lord, then I may not file this exception, my lord, because it is a.
Yes, 9.
Look, here we have.
Who are you for?
I am from the petitioner.
Come this side. Yes, what is it?
Milord, here the petitioner's wife.
Hmm.
Petitioner is the wife of one Sheikh Manu who was retired and from the said respondent office and received a lot of money lesser. Milord, in the report filed by the respondent, Milord, kindly see page 7. Annexure.
What is your prayer in the writ
Milord,
petition?
my prayer is that in their report 7.
No, prayer in the writ petition.
Milord, we have got lesser retirement benefit, Milord. Milord, how? Milord, kindly see their report of the court case.
When did your husband die?
Milord, in the year 2012. From the
Why are you filing the writ petition in 2025?
Milord, we are illiterate, we are going to the office. They are
Does the illiterate have different rules?
Milord, kindly see point number 7.
Of what?
Of the court case.
The court case.
No, before that, my lord, what is
Let him explain himself.
Let's see the document submitted by them in point 7. Milord, the said insolvency case was dismissed with a direction to refund the retirement holding amount to the petitioner's husband. If it is returned, then that amount which was stated in page number 7 in annexure R2 of their report is not matching, Milord. 91,000.
When did your husband die?
2012, Milord.
And when did he die in harness?
No, Milord.
He was superannuated, then he expired.
2005.
When was he superannuated?
Milord, in the year
2006 or 2005.
2006, Milord.
2006, date of retirement. Now, when did he die? In 2012. The widow is coming forward in 2025. Why will your writ petition be maintainable?
No, Milord. Kindly see how many representation we have made.
Who has made?
He said the petitioner, his widow.
Yes. What representation did the employee make?
Employer only giving. We are seeing, Milord.
There is nothing on record to show that the employee made representation.
No, Milord.
Nothing.
They have give.
Please come.
Only thing, my lord, what is his prayer? That payment has been made, provident fund. Now he has come. When I file a report, he is saying these cases are pending. What is the case for? What is his prayer, lordship?
A dismissed case claims to be the widow of a deceased employee of the Shama Prasad Mukherjee Port.
Milord, kindly see the point 7 of.
Stop. He retired from service in the year 2006 and he expired in April 2012.
My lord, he retired from 1/4/2005. In my paragraph 4 of my report.
1st April 2005.
5.
No, 1st April have 31st March have 31st of March 2005 and died 7th April 2012. Yes, sir. On 26th of June 2025, the petitioner has filed the instant writ petition. And sought for certain information as regards the Provident Fund disbursement in favor of her deceased husband. Stop paragraph. The petitioner has averred in the writ petition that her husband did not receive the provident fund money and a deduction of certain amount was made from his terminal dues. Stop. The petitioner has not averred anything as to where from she received the information that her husband did not receive his legal dues. Stop. There is no document annexed to the writ petition to show
9, Milord,
that the husband
page number 9 and the checks which I annexed
ever
page number and
filed
20.
any representation before the authority
Yes, Milord.
claiming payment of his legal dues.
Milord,
Stop.
there are two other represented in page number 18 and
It is only the
number
widow
24.
who has come forward with the claim of non-payment of the terminal dues of her deceased husband. Stop. No reason has been mentioned as to why the petitioner approached the court. Nearly 13 years after death of her husband and nearly 2 decades after her husband stood superannuated from service. Stop. From the report filed by the senior accounts officer within bracket pension section of the
Paragraph 4, Lord, you can see.
authority,
Paragraph 4.
it appears that the employee was eligible for payment of gratuity for a sum of rupees 1,86,031 and commutation of rupees 1,23,763, totaling rupees 3,09,794. Stop. A sum of rupees 1,78,115 was adjusted, being recoverable amount on account of the various dues of the deceased employee. For example, Calcutta Port Trust Employees Cooperative Credit Society, court attachment, etc. Stop. After adjustment of his dues, a sum of rupees 1,31,679 was paid to the employee on 2nd March 2006. Stop. The report paragraph, the report further records that from the records of the PF section and that of the mechanical engineering department, the settlement of the provident fund dues amounting to rupees 16,473.03 was processed and the same was paid in favor of the employee in October 2005.
That is his claim in the writ petition, entirety, provident fund only.
Stop. after death of the employee, comma, family pension has also been granted in favor of his widow, comma, the petitioner herein. Stop. The respondents have categorically mentioned that there is no due amount payable in favor of the deceased employee. Stop. Paragraph.
Milord, kindly see this paper.
The
column
fact
second.
that the employee himself did not raise any issue for the entire period from April 2005 till April 2012, as long he was alive after his superannuation, alleging non-payment of any of his terminal dues, comma, implies that the employee was satisfied with the payment that he received after superannuation. Stop. Even if there had been any claim, comma, the same appears to have been waived by the employee. Stop. At this stage, the issue of non-payment of retirement dues, if any, comma, cannot be allowed to be reopened at the instance of his widow. That too, comma, nearly 13 years after the death of the employee. Stop. The writ petition fails and it's
Milord, he has acknowledged that adjustment payment, page 9 of my report.
Paper,
LTI.
Milord,
return this paper.
Milord,
Next.
here the columns 7 has not been mentioned, Milord. Where
Call the next matter. 11.
Yes, sir. My lord, I am appearing on behalf of the petitioner of the last day. They have paid for time. The petitioner is the second impaneled candidate. His petition was moved on a single bench, directing the Sonic School to consider the appointment of the petitioner by setting aside the appointment of the first impaneled candidate. First impaneled candidate obtained the fake certificate, Madhya Bharat, Bihar.
Madhya Bharat?
Bihar.
Bihar.
State board. And
Alright.
the CBI investigation is going on against the state board, my lord. Stated. Thereafter, lordship can come to the page 22. Relevant part, my lord. Page 21. After considering the submission of the learned counsel appearing for the petitioner matters placed on record, this court directs the representation data such and such to be considered in the light of documents annexed page 35 of the writ petition being a confidential memo issued by the head branch CBI to the chief secretary. Let personal hearing to be given to the petitioner as well as the respondent number 6 within 6 weeks. Let the reason order be communicated to the petitioner within 2 weeks. In the event first impaneled candidate respondent number 6 appointment is set aside or cancelled due to the procurement of fake certificates evidencing educational proof of his qualification, let the second impaneled candidate be considered for appointment in his place. Thereafter, my lord, Sonic School preferred an appeal before the Honorable Division Bench, page 23 to 25. Relevant portion, my lord, 24. Para 13. Learned by the impugned order, learned single judge considered the appointment to the post of Group D of the Sonic School. Learned single judge cancelled the appointment of the first impaneled candidate, namely the respondent number 6 in the writ petition due to the fake certificate using educational qualification as proof. Learned single judge direct the consideration of the appointment of the second impaneled candidate being the writ petitioner instead of place of the cancelled employment. Writ petitioner fulfilling the necessary criteria. Appeal is at behest of the Union of India and Sonic School, Purulia, their functionaries. No right of appellant stand infringed by the impugned order. Person whose employment was set aside is not before us. The appellant at behest of the employer, no right there can be said to be violated by the impugned order. It is not the case of the appellant that the respondent number 6 in the writ petition did not produce the fake educational certificate. No personal hearing was given, and thereafter we made a representation, my lord.
All right, let me hear. Yes, the fate.
Yes, my lord. Firstly, my lord, the HON'BLE guy, that is the respondent number 6, he has been removed. Number 1. Number 2, he was summoned.
Removed because of fake certificate?
Exactly. Because, my lord, it was clarified subsequent thereto by the authority that this certificate was not issued. Now, my lord, with regard to the personal hearing, my lord, he was issued a notice. He appeared on the, my lord, 10th November 2025. On that,
Petitioner appeared.
yes.
My
Petitioner,
lord.
Wait. Yes.
Petitioner appeared.
Huh?
He was shown all the documents. But when he was asked to put a signature, he declined to put the signature. Why? I am saying, submitting. Because, my lord, his rank is 1, 2, 3, 4, 7.
How many vacancies?
My lord, only 2 vacancies.
All
Now,
right.
my lord, in the place of HON'BLE Gayan, one Sri Topon Kumar Gorai has been already been appointed because his rank was 4th.
All right.
And he is 7th. When it has been placed that all the marks that he has obtained as well as the next candidate, for such reason, my lord, as there was a direction passed by the my lord, single bench earlier that the next candidate will automatically will come. Now, my lord, that Topon Kumar Gorai has been appointed. Now his rank is, my lord, 7. For such reason, he could not be offered. Not only that, he was intimated on that day when that the to be considered in for filing future vacancies if arises within the calendar year 2020. That was intimated to him on this very initial stage. That in the year 2020 there was no vacancy. For such reason, his claim does not arise.
My lord, order was passed on 2022. No personal hearing was given. They have served a notice after 3 years. And no personal hearing was given because I was present in the Sunigi school and Sunigi school authority did not allow the learned advocate also. Thereafter, we made.
Why will are you going for a job? Why did the learned advocate go?
My lord, they did
Lord, I
not
have
allow
the
me
instruction.
filing.
What he did,
They called
being a
just-
learned advocate, what he
have
did, my lord, I have the instruction. I can
Yes,
put it on affidavit.
Yes, my lord. I have submitted the written argument also, my lord. This is my submission.
There was a more than 70 people
Even
mobilization was there.
In 2022, they have served a notice. Only notice, my lord. Lords, you can come to the notice. They have issued a notice on 30 October 2020.
Did you hand over a copy of the supplementary?
Yeah, today.
How will he go through it?
Yes.
Which page?
Because I have that.
The last page.
Last page.
Written notes, my lord. Para 6. And honorable single one directing the authority
Now,
to
Milord,
pass a
yes,
reason
Milord,
order.
now, Milord,
No
kindly
reason
come
order
to
was passed.
page 4. He
They
has
have
been
issued a
intimated,
notice.
everything. Wherefrom
Order-
he has got?
Order was passed 2022. Lords, you kindly come to the page 22.
No, 22 is over.
Yes, my lord.
2025, you were given a personal hearing.
And
No
he has,
hearing was given, my lord.
then
They
how he did, how
called the
did he get
person,
that?
Petitioner. No hearing was given. They have submitted the written argument. That has been refused. Thereafter, we written argument submitted by post, and no reason order was passed. Lords, you can come to the order passed by the single bench. And thereafter, appeal has been papered by the Sonigi school. Late personal. Yes.
Appeal is long over.
Yes.
Now, thereafter, they gave you a chance.
Yes, my lord. Order was passed
And
in the year 2022.
Milord, kindly read that.
Order was passed in the
Please
year
come.
22.
It is better you file by way of a report because this will be carried in appeal, and if your stand is not there, then that will be difficult.
As your lordship.
This supplementary affidavit on behalf of the petitioner filed in court today is taken on record. A copy of the same has been handed over to the learned advocate for the respondents in court. Stop. According to the respondents, the order passed by the Honorable Single Judge on
my lord, 8th December
8th of December 2022 in the earlier writ petition filed by the petitioner, being WPS 7489 of 2021, has been complied with. Stop. The petitioner was granted an opportunity of personal hearing. Stop. The petitioner failed to secure the rank for which appointment could not be given to him. Paragraph. Let the respondents file a report by way of affidavit disclosing their stand within a period of shortest time.
As your lordship, please.
3 weeks. Today is 10th.
Milord, next week, Milord, up to 29th, Milord, there will be no mobilization.
You want to do it prior to that?
No, after that.
You want after that?
After that.
Very well. 6th of May.
My lord.
Release the matter on 13th of May.
My lord, in
As
terms
your
of the
lordship.
single bench order, let reason order be passed, no reason order be passed.
All right, next.
He has annexed the reason
No,
order.
yes, no reason order. This is a written argument.
Next.
I am for the petition. This matter
I am appearing with respondent number 123.
relates to
Please come this side, they'll have a place. Yes.
this matter relates to inclusion of the petitioner under the central pension scheme as introduced. What happened, Milord?
Introduction of the petitioner in
Inclusion of the petitioner under central pension scheme.
Central Pension Scheme. All right.
What happened, Milord? Petitioner before your lordship is a retired employee of Airport Authority of India.
All right.
Milord, in course of after retirement, the central government floated a scheme in 2017 saying that all the employees who were initially employed as a central government employee, subsequently they were absorbed in National Airport Authority and thereafter came under the purview of Airport Authority Act. This type of person having 10 years less than 10 years service, they would be included under the central pension scheme. Accordingly, options were asked. We exercised option that was processed. In between the period, there was a rejection that it was a belated application. We moved this honorable court given certain reasons that you have given certain persons. Then, Milord, in course of the matter, their names were considered. Airport Authority sent their name, and it is on record that their names have been accepted. Now they are in the zone of consideration. Then, on that score, in dealing with the matter, the concurrent bench passed in direction to have an instruction because Airport Authority and other authority has recommended their name. It is admitted position. The Freer egg is no more in German, Milord. So far as the second part is concerned, now a report was sought from the central government. Central government ultimately has given a report. According to them, they are not saying that I am not otherwise eligible. What happened, Milord? Initially, when the petitioner was a Airport Authority employee, they were covered by Employee Provident Fund scheme. There is a department. This is also central government given. Now the fight between two departments. Central government said, unless that payment of pension is stopped, I cannot give. Then there are correspondence. I will show the corresponding between the two points. I say that I will not opt for dual pension. Whatever amount you recover it from my amount and release it, and accordingly, more than 60% of the such type of employees have been given pension. They are getting it. In fact, they are getting dual pension. I said on oath that I will not take dual pension. I want to stick onto the central pension. Otherwise, you are not finding me ineligible. In between the fight of the two departments, my case has been stated. This is the substance of the matter, my lord.
All right.
My lord, last occasion, my lord, we have my lord.
Who are you representing?
I am appearing for Union of India, respondent number, my lord.
And another thing, my lord, such type of cases, because number of zones are there.
Who are you representing?
AI.
I am
Airport Authority.
1, 2, 3.
Airports Authority.
Yes.
And you are for the Union of India.
Union of India 4, 5, and 9.
You for the Provident Fund
4,
organization.
5, and 9. Last occasion, my lord, we have my lord submitted my lord the report in the form of affidavit.
You are not accepting. Who is not accepting the claim of the petitioner?
My lord, on last occasion before the my lord previous bench, my lord, it was not decided who is the my lord pension sanctioning authority. In here, my lord, here from the affidavit, it is my lord clear that DGCA is the my lord pension granting authority.
Who is the authority?
DGCA.
All right.
Civil Aviation Department.
Uh-huh.
And my lord, the AI has not my lord recommended and sent my lord the file to the my lord DGCA. DGCA, my lord. That
is also your authority.
AI, my lord, he's
Airports Authority is going to send it to you.
Yes, my your lordship, kindly
Authority
see page, my lord, page 4, my lord.
Yes.
Para 10, my lord. The AI Eastern Regional Officer, AI Kolkata.
1 minute. Page 3, you say that the petitioner was included in the retirement benefits of the Airports Authority and granted EPF pension applicable to all employees of the AAI.
Yes, my lord.
There was an option to exercise for the retiring employees, AMAS Absorbed. The petitioner falling applied. Yes, then where is the problem?
Problem is that your lordship kindly see page para 10.
Para 10.
Page 4.
AAI is responsible for processing the pension case. He
That
has not, the AAI has not recommended the petitioner's pension to the DGCA.
Yes, my
due
lord.
to non-stoppage of EPF. Who is going to stop this EPF? Now the EPF comes
Now
in.
EPF comes, my lord. EPF, my lord.
Lordship,
That problem
just first part, it is not according to them, it is not recommended.
Page 11.
It is
para
recorded
11.
in the order. My name has been forwarded. It is recorded in the earlier orders. Lordship, kindly.
My lord, may I
EPF
submit
recovery of pension?
on behalf of AI, may I submit the real problem?
Yes.
What happens?
I do not want to know the problem. I want to know the solution.
I am coming to that point.
Yes.
But what have been alleged by my line?
Forget the allegation. How do you solve the problem? Tell me.
My lord, Airports Authority already recommended
Recommended?
their case.
Yes.
That is a supplementary affidavit. Lordship, kindly see, it is recorded in the order itself. He is not proper. I'm going this. Lordship, kindly see my exception. Exception page 8.
Recommended that point, my lord.
Yes, please.
Kindly see the document appearing at exception of the petitioner at page number 11. Their
petition?
Exception of
Yes, exception
to
page
the
11.
report filed by the Airports Authority.
Yes.
Page 11.
Right.
My lord, in this regard is informed that government pensionary benefit has
Bhattacharya's
been
name
approved
approved
for the following employees. Now, serial number 3 is the petitioner.
Yes.
So it is not that Airport Authority has not recommended.
But to who did you recommend? You have to forward it to the
to DGCA, my lord.
Where is this forwarding?
Yet to be done. Real problem is coming. My lord, kindly see the conditions.
No, in para 11, DGCA clearly said that
you will submit.
If they will send, my lord, they will, my lord, consider.
When will you send it?
In that issue, many cases are pending.
When will you send it? Tell me. When will you forward it to DGCA?
My lord, come to page number 12.
Yes. Page number 12.
Condition. Page number 12, para 3.
Yes.
As stipulated in MOCA order number so and so, these employees are not eligible for receiving AI superannuation benefits, that is employees defined contribution pension scheme, benevolent fund scheme, employers contribution, CPF and EPFO pension. My lord, after absorbing with Airports Authority, they are getting this facility. Thereafter,
the
it was
petitioner is agreeable if you stop, if you recover what he has received.
My lord, we cannot record pension already they have drawn. Now pension authority has to stop their payment. Thereafter, their
Who
final
is the
processing.
authority? Who is the authority?
EPFO authority, even dispute is there.
When the contribution has come up, my lord, it is after 50 years or 8 years of retirement, my lord. It automatically goes. Our law is been governed by the EPF Act, my lord.
Yes.
It's been governed by the CCS Act, my lord.
True.
So we have been bounded by that because the contribution to the pension fund has already gone there. So we had given as per our act, my lord. As per the act says out, soon after 50
I have followed it. Who is the superior authority? Tell me. Who is the top authority? You will not be able to do it. Who is the authority?
DGCA, my lord, is
the
Airport Authority of
sanction.
India.
Airport Authority
Airport
has got
Authority of
no role
India.
now. My lord, in this matter, similar issue has been decided by the coordinate bench.
What has the bench said?
This is another issue, my lord. The names were not said.
Bench said.
Kindly
What has the bench said?
Yes. 6 number cases have been decided.
Well, the names have been, lordship kindly turn order itself. Order itself it is recorded. Order itself it is recorded. Name.
Very clear.
These are completely different issues. Names were not said.
Different. Same issue. Same issue. My last.
What?
is made clear. The direction.
Civil Aviation Department and the AAI to take a final decision. This is the order.
Para page 3.
Yes.
Last para.
Yes.
In view of submission made on behalf of the parties, all these petitions are disposed of by directing the Civil Aviation Department, Government of India, Department of Pension and Pensioners
Please come.
Welfare Department and the AI to take final decision in so far as the grievances of the petitioners.
The petitioner is a retired employee of the Airports Authority of India. Stop.
I know decision has to be taken
Even
by
though
the Pensionary Department and Civil Aviation Department.
even though
They are
his name, even though he has been recommended for grant of government pension in terms of the CCS pension, what is that act called?
Yes.
CCS
Pension Rule 1971.
CCS pension rules.
EPF, Employees Pension Fund Scheme 1995. They are drawing now.
Where is the name of that scheme?
Employees Pension Scheme.
Included
Employees
under-
Pension
under
Scheme 1995.
But I have in the prayer B framed under CCS Pension Rule 1972.
CCS pension.
No, that is the government pension. I am telling you, they are drawing EPF pension now. That is why problem is arising.
The issue is that the petitioner has already received the Employees Provident Fund.
Employees Pension scheme.
Under the
Employees Pension.
EPFO's pension scheme.
EPS scheme 1995.
1995.
EPS.
Yes.
EPS 1995.
Right.
Until the same is stopped, the petitioner cannot be given the benefit under the CCS errata. ঠিক আছে? Stop. The Airports Authority of India, the DGCA and the Employees Provident Fund Organization have filed their respective reports. Stop. The problem of the petitioner, however, could not be solved. Stop. Paragraph. For finding out a solution to the problem that has cropped up so that the petitioner receives his pension in terms of the CCS scheme.
EPF.
The matter is referred to the Director General of Civil Aviation for taking a decision in the matter. Stop. The matter is made returnable on 11th May 2026. Stop. A report shall be placed before this court on the adjourned date, clearly specifying the formality which the petitioner is supposed to undertake for receiving benefit under the CCS scheme. ঠিক আছে? Come back.
রিপোর্ট কে দেবে? ডিজিসিএ তো রিপোর্ট দিয়েছে অলরেডি। হুম। রিপোর্টটা কে দেবে? রিপোর্ট
13
সেন্ট্রাল গভর্নমেন্ট বলবে।
আমি তো ডিজিসি অলরেডি রিপোর্ট দিয়েছে।
আবার দিতে বলবে।
I put the petition on lordship. না দিলে তো হবে না এয়ারপোর্ট অথরিটি।
Transport Corporation. Yes, amount deducted from the terminal dues of the employee.
Lordship.
What is the amount that has been deducted and on which ground?
An amount deducted, I think, is 2,68,000 and odd.
How much?
2,68,844.
2,68,846.
844 or 46.
46.
46.
Yes.
Only on the ground of erroneously having made the payment. On the basis of erroneous fixation due to ROPA rules.
Erroneous fixation
This
because
is the
of
report.
ROPA.
Once you are directed, I am appearing later on subsequently. This is the report file.
Given a copy?
No. Hardly there is anything. That was देखा ना दो paragraph लिखा है. That is not
Whoa. What is mentioned?
Now kindly takes paragraph 3I at page 2. These pages of the kindly see the last line. But due to erroneous fixation under ROPA 98 and ROPA 9, an amount of work done from June 2002 to May 2018 amounting to this much.
From 2 to 18? What was his normal age of superannuation? Had he been superannuated?
এটা তোমায় বলতে হবে. My lord, he joined. যদি রিটায়ার না করতে মানে মানা না যেতেন কবে রিটায়ার করতো বলছি.
His qualifying service period was 34 years.
That's right.
That means he was of ripe age. But then how many days more did he had prior to his superannuation?
That
at the age of 58 years.
50 years.
Right. So he was nearing his superannuation.
That's right.
And from 2002 to 18, 16 years you give him the pay, and now you, after his death, if you seek to recover, is it permissible? Then?
But I have made my submissions, Lord. She will record it and pass the order. I can't make submissions. I cannot.
Give me the Rafiq Masi judgment, please.
I've brought that also.
Please give. And something later to Rafiq Masi?
But I have possibly paragraph 617 or 618.
No, after this, this is a 2014 Rafiq Masi. Where is it?
That was 2018.
2015?
Yes, this is not that. That is the bhool আগেরটা এনেছো that.
Wait, let me see. No, it's the earlier one.
Yes, that's right.
No, but then there is a recent judgment also. There is a recent judgment also.
Well, I'll bring that. Your Lordship keeps it in the second half, I can bring it.
Yeah, all right. Please.
Second half is difficult, Lordship. Kindly Monday.
না অসম্ভব.
All right, only not today. No, আসুন তো দেখি. Report in the form of affidavit filed by CSTC. না কি বলে? হ্যাঁ, CSTC. In court today be written with the records. Oh yes, I have Rafiq Masi over here. Wait.
Paragraph 17 or 18?
18.
Bhool judgment in it.
Come. It's taken on record. It appears there from that. On account of erroneous fixation under ROPA 98 and ROPA 2009 for the period from June 2002 to May 2018.
99, 2098 and 2009. Yeah,
The employee was paid a sum of rupees 2,68,846 in excess. Stop. The same was detected after the expiry of the employee on 10th May 2018. Stop. The widow has challenged the recovery process and has prayed for refund of the amount deducted. Stop. Paragraph. Learned advocate for the petitioner refers to the judgment delivered by the Honorable Supreme Court in the matter of State of Punjab and others versus Rafiq Masi within bracket whitewasher, reported in 2015 4 SCC 334, wherein the court laid down the situations where recoveries by the employers would be impermissible in law. Stuff. it had been categorically laid down that recovery from the employees belonging to class 3 and class 4 within bracket group C or group D service is impermissible. Stop. The husband of the petitioner was serving in the post of helper, which is a
Security guard, Lordship.
group
Security guard.
security guard.
Lordship.
He was absorbed as helper, it is mentioned, and he previously cleaner. Whatever, it's a group D post.
Lordship.
In a group D post. Designation in a group D post. Stop. And the period for which the excess payment has been made is in excess of 5 years. Stop. In fact, the employee enjoyed the excess payment for nearly 16 years prior to his death. Stop paragraph. The authority could not have deducted the aforesaid amount from the death benefit of the retired employee. Stop. Next, in view of the above, the action taken by the respondents by deducting the excess amount from the gratuity paid to the petitioner cannot be accepted in law. Stop. The authority is directed to refund the sum of rupees 2,68,846 which was recovered from the amount from the due amount of the employee shall be is directed to refund sum of rupees recovered from the gratuity amount of the employee on account of overpayment positively within a period of at the earliest, but positively within a period of 8 weeks from the date of communication of this order. Stop. As the amount was erroneously deducted from the benefit of the employee, the same shall be refunded with interest, calculated, simple interest, calculated at the rate of 6% per annum on the aforesaid amount from the due date till the date of payment. Disposed.
Please, your lordship. My lord, this is on last occasion. Question was put to LICI that when there is a notification, I'll give a very short background, my lord. A notification was there for to an extent for the revised pay scale. However, that particular notification says that if any of the development officer has any of the cases which are pending before any of the court and there is a stay order, then they are not eligible for such revised pay scale. Being aggrieved, challenging that, the writ petition preferred this, the petitioner preferred this writ petition. Now, my lord, at the same time, in the writ petition, they have relied upon an internal document and which is annexed at page number 123, which says that the development officer should be treated equally. So at this juncture, my lord was pleased to direct us to take instruction that how come when there is a notification of 2024, this notification carries from 21 and 16 backward, this office order can be passed. So this is my instruction. I am here to address that much only, my lord. My lord, first and foremost, my lord, with deepest of respect, if my lord kindly comes to page 123, this is first and foremost, this is an internal office note which is confidential in nature and not for public use. Secondly, my lord, this notification or this office order has been read, or if I may use the word, has been misinterpreted by them, because I want to take my lord through this office order once again. Allow me to please, my lord. It says that it is noticed that sometime some of the development officers who attract termination under the provision of special rules as amended from time to time seek legal recourse and get stay order from the court of law on show cause notice, termination notice, the process of termination initiated by the corporation. Currently, as informed by the different offices, many such matters are sub judice in various court of law. By virtue of such stay order issued by the court of law, all the petitioners continue to be on roll of the corporation as employees with same basic pay and allowances as that he or she was drawing as on the date of the stay order. In view of the above, you are requested to note that such development officers are to be treated alike or equal with the other development officers against whom no proceeding under the provisions of rules as amended from time to time are initiated. And therefore, the business performance of this development officer shall be reviewed under the provisions of special rules as amended from time to time for the appraisal years after stay order. The appropriate annexures shall be issued to the petitioners under acknowledgement. Kindly instruct the office under your jurisdiction accordingly to ensure that the appraisal of such development officers are reviewed every year regularly and appropriate annexures are issued as done to all the development officers. It is also necessary to take steps in liaising with the respective legal department for vacation of the stay order on priority basis. My lord, now my lord, they want to interpret that this office order or this is an internal communication which has stated that we should be treated equally. My lord, with deepest of respect, I put this question to myself from reading of it, where it says that they have to be paid equally. My lord, first and foremost, kindly come to the first paragraph, the last line, which says, continue to be on the roll of the corporation with the same basic pay allowance as he or she was drawing as on that date. It says that as on the date of the stay order, whatever his basic pay was, he will be entitled to that. It never says, this line never says that after the stay order also, his basic pay will go on increasing. First, this has been wrongly been interpreted. Second, my lord, second paragraph, it says, in view of the above, they are to be treated equally alike with other development officer, and therefore the business performance of this development officer shall be reviewed. My lord, with deepest of respect, this means that since they are into employment, so there will be targets and there will be appraisal depending upon fulfilling that target. This office order says that they have to fulfill that target also for subsequent appraisal years, because his appraisal were not, or his performance was not correct or not up to the mark. That is the reason show cause notice was issued and termination notice. That particular, for that non-performance, it has been stayed. But he continued to be in service. If he continues to be in service, he has to carry on business or meet his target according or at par with the other development officer. This second paragraph deals with that he has to fulfill his targets which are given to the other development officer. Now, my lord, the last part, it says that his performance will further be reviewed every year. Now, my lord, bare reading of this, from where I put this question to myself, it says that they have to be given the benefit of the revised pay structure, because a notification which is a public document and which is they are supposed to receive, that clearly says that clause 20, you are not entitled for that. Being aggrieved, they have preferred this writ petition. That will be decided on merit. But my lord, just an internal confidential office order, which how they have got hold of, they have never disclosed this. This is not for public.
It is for you to find out how it has gone out.
My lord, they are employees somewhere, they have got from somewhere.
Yes, then why questioning?
Very well, very well.
He is not supposed to disclose the source.
They have got it.
Yes.
My lord, with deepest of respect, this is not a public document. This is not a notification. So they cannot ask. And secondly,
Is it not your document?
This is my document. It's an internal document.
Yes.
And secondly, my lord, this particular document in strict sense never says that they should be paid equally or in contravention with the notifications that is there. So, my lord, my point, as I have argued in the last writ petition also, which my lord has already kept in me monthly list, I'm giving that writ petition number where the point of maintainability was in detail heard. And my lord,
Did you file your opposition over here?
no, my lord, because that maintainability, if my lord remembers that other writ petition, WP number 25556 is of 2024, wherein my lord in detail matter was heard, additional written notes has been filed with
Should
further.
this be heard along with that?
Yes, my lord, because all are same issues. My point is same. My point now, coming back to the merits of the matter.
Would you not like to file an opposition over here
My lord,
separately?
because my maintainability point I want to urge, that is the demerit.
All right, let me hear once.
My lord, the interpretation which has been sought to be given by the LIC.
The interpretation I'll hear later on.
Yes.
Can this be posted along with the other matter? He says it is fixed
My
sometimes.
lord, it may be posted, my lord. The only thing is that I am covered by a coordinate bench interim order, my lord. I am praying that my
Similar interim order.
yes, similar interim order.
Where is that?
My lord,
Where is that interim order?
that in a different writ petition, my lord, WPA 2600 of 2024.
The other writ petition, I specifically took that point that interim order is not binding on this coordinate bench because the maintainability was not urged over there.
My
on
lord,
that aspect, my lord has heard, the other coordinate, Justice Mukherjee has heard us on the maintainability, and on the last occasion, I have narrated the maintainability. So maintainability issue has to be decided first because, my lord, the notes has also been exchanged. So right now, in garb of when my maintainability issue is open, he cannot ask for this interim order because,
my lord, the interim order
bench order he is relying upon, there the maintainability was not challenged.
And the interim order
was
not
made.
challenged.
Yes, it was challenged, my lord. Appeal was dismissed, and the interim order was
I'm
made
not saying,
subject
but
to
that is
disposal
not
of the writ
final
petition.
order. That is not the final order.
Interim
And the
order, my lord.
maintainability- And there is
My lord, may I submit?
just
The-
once last submission, my lord. With deepest of respect, my lord, that interim order so granted, it is not binding on a coordinate bench. My lord is
Now it is the discretion of the court to see whether I'll
and
act in
at the
accordance
same
with
time,
it or I'll defer.
my lord also keeps in view, because this matter is of 2024. Since 2024, they are trying for this interim order, and the court has already entertained us on the maintainability point, and court is already hearing on the maintainability point. So unless and until the maintainability point is decided, with deepest of respect, my lord, granting an interim order is a subsequent stage, because first the court has entertained. I would have understood that court has not entertained me on the day one, stating that I will not entertain you on the maintainability point and I will grant the interim order. I would have understood.
For this matter, it is the day 1 or 2 because I see only one order over
But
here.
because it was tagged with that other matter on which the main hearing was going on. In that matter, there are 3 petitioners. Here, there is 1 petitioner. This learned advocates, they filed.
This petitioner
Because my lord, it was all along being heard together.
Then let's say
My
motion
lord,
will pass for the time.
Yes, my lord. I am.
But with deepest of respect, my lord, the matter which was being heard, that is WP 25556, no interim order was granted.
Very well. Let me give me the order, please. The earlier order.
And my lord, that 2555 order, I'll just
2600.
I am what I am.
2024.
What I am.
Yes, Anupam Verma.
Just Mantha Sahiber order.
Anupam Verma.
Yes, this is the one.
Please.
This is the one.
Please give me a copy of this.
But my lord, here my lord would see that the point of maintainability was not.
All right, I get it.
Just one submission, my lord.
Yes.
The division bench, upon categorically noting the fact that the interim order is made subject to the outcome of the writ petition, refuse the appeal, my lord. We are asking for a similar interim order.
No, my lord, they cannot ask for a similar order for the reason that in that writ petition, maintainability was not challenged. My specific
Let the maintainability point be kept
very well.
open.
My lord, hears me now. Hears me now on the maintainability issue. I'm ready to urge. Because, my lord, this is an executive decision. Executive decision cannot be challenged by way of a writ petition.
Please come.
It,
The petitioner
Dada.
claims to be similarly situated as the petitioners in WPA 2600 of 2024, Anupam Burman and others versus Union of India and others. Stop. Prayer has been made to pass similar order as passed by the court passed by a coordinate bench of this court on 22nd March 2024. Stop. It appears
My lord, may I just interrupt for one moment?
Yeah.
There is a 19th March order as well. This is 22nd March, 19th March order, my lord. My lord's court officer is kind enough to get a printout, my lord.
All right.
Over there, the learned singer has gone into details as to why the interim order should be granted.
All right. देखिए अच्छा डेटটা কবে বললাম 19th March 2024 and 22nd March 2024 ঠিক আছে
My lord, may I just say one small thing, my lord? In case my lord is considering of passing the interim order, my lord, hear me for a moment, because my lord has not heard me to an extent the merit of the matter. If my lord is considering, my lord.
Paragraph. On a perusal of the order dated 19th March 2024, followed by the order dated 22nd March 2024, it appears that the court heard the parties at length and passed interim order upon hearing the parties. Stop. The court was pleased to direct as an interim measure that all the revision that the petitioners were entitled to with effect from 2021 within bracket the date of implementation of the central government notification bracket close shall be paid with effect from January 2024. Stop. The court further directed LICI to revise the pay slips of the petitioners and reissue the same accordingly within a stipulated time period. Stuff. All the benefit that was granted to be paid would abide by the result of the writ petition. Stuff. The court directed the parties to file affidavit in opposition. Stuff. Affidavits have already been filed in the matter and the same is ready for hearing. Stop. Paragraph. Challenging the order passed in the matter of Anupam Burman within bracket Supra. An appeal was preferred by LICI. Stop. Give me the number of the appeal, please.
My lord.
My lord, MAT number 760 of 2024.
Yes, 760.
760 of 2024.
The matter was carried in appeal being mat number such and with a order dated 31st of July 2024, the Honorable Division Bench was pleased not to interfere with the interim order passed by the learned single judge. Stop. Paragraph. The petitioner prays for similar relief. Stop. Learned advocate representing the Life Insurance Corporation of India opposes the prayer of the petitioner. Stop. It has been submitted that the issue of maintainability of the writ petition was not raised in the matter of Anupam Burman. Stop. The petitioner, LICI, intends to challenge the maintainability of the writ petition. Stop. It has been submitted that till the maintainability issue is decided, the court ought not to pass similar order as has been passed by the coordinate bench in Anupam Burman within brackets Supra. Paragraph. Upon hearing the submission made on behalf of the parties and on perusal of the orders passed by the single bench and the honorable division bench in the matter of Anupam Burman and others, it appears that the court has already gone into the merits of the matter to some extent and had been pleased to pass an interim order, which stood affirmed by the honorable division bench. Stop. It is not the case of LICI that the petitioner herein is not similarly circumstanced as that of Anupam Burman within brackets supra. Stop. That being the case, comma, the court is inclined to pass similar interim order as has been passed in the matter of Anupam Burman. Stop. The not the LICI is directed as an interim measure to revise the petitioner's pay slips with effect from January 2020. When was that writ petition filed? Earlier, from January 25. Stop. The arrears of the petitioner shall be paid within a period of 8 weeks from date. Stop. The benefit granted to the petitioner in terms of this order shall abide by the final order passed in the writ petition. Stop. The not the LICI will be at leave to file affidavit in opposition to the writ petition within a period of 4 weeks, reply if any within a fortnight thereafter. Stop. Liberty to mention the matter for hearing immediately on completion of the aforesaid time period. Stop. The all right.
My lord, just one small leave, my lord. Since my lord has already passed this order, my lord, let the leave be given to LICI in case if his termination is upheld, because I will be paying this amount. The moment I will be paying this amount, tomorrow the Supreme Court is already hearing this matter and there is no stay order. Tomorrow, if the rules are upheld, then automatically his termination will be
Subject
upheld.
to outcome.
Yes.
His termination, then I should have the liberty to recover this amount in future.
It is mentioned subject to the final order.
But my lord, kindly, because this,
In the event the petitioner is unable to succeed in the writ petition and the writ petition filed by the petitioner fails, comma, it will be open for LICI to take steps for recovery of the amount paid to the petitioner in terms of the interim order passed.
I'm so grateful.
My lord is granting the arrears from 2025.
2025 January, you filed it in December 24. How can you get it from
My lord,
prior date?
my lord.
I'm so grateful, my lord.
I'm grateful, my lord.
My lord, may fix this matter with that because maintainability.
That one is being heard. It is division bench.
That is kept, my lord has kept hearing that maintainability in the monthly list of me. I'll just give the writ petition number. Let this be tagged with that because
Cannot be because the dates won't tally. I've given you 4 weeks time to file your opposition. So whatever is order is passed over there will certainly
very
abide here also.
I'm grateful.
More
Your Lordship, appearing on behalf of the petitioner.
Lord, I am supposed to start my argument today, my Lord. I am seeking 1 day's accommodation. Lord, the brief,
Accommodation.
1 day.
Because it has been accommodated on earlier occasions also.
Lord, the state had last finished. My learned
Back.
Lordship,
I'll forget things now.
take it next Saturday, next Friday, my Lord. I will not seek time again because I need to go through the briefs.
You must have been ready in the
No, my Lord, I was not ready because the brief was not with me. I've been 2 days back. I've got the brief. I haven't had the time to see.
Your name is there every day.
Not 1 day's accommodation. Only next Friday I'll do it without fail, my Lord. I won't seek an adjournment. And it won't be a very long submission of mine also.
আগের দিনের recording.
Court can caution FIR or the proceedings. When there are
You can make your arguments on that score, whatever you've got to submit.
I need to go through the documents. That is why. My oral submission will not suffice here.
Learned advocate representing the private respondent, namely Shafiq Ahmed. He's your client?
Shafiq Ahmed is my client. And Mamta Agarwal.
Both?
Both.
And Mamta Agarwal, private respondents. Seeks time to come prepared. Stop. Paragraph. On such prayer, hearing of the matter stands adjourned for the day. Yes, call the next matter.
Much obliged.
on next Friday, if my lords permit me.
It is there in the list. It will appear in the list next Friday.
So that in the top, my lord, first matter as a first matter in.
Yours is the second matter.
But today it's second matter, my lord.
Yes.
If
Next date will not go down to any other thing. It will remain there.
my lord,